I have 1 o'clock, so good afternoon, everybody. This is Ed Crowe. We're gonna do a short webinar today. It's 6-7 slides. It'll be quick. When I scheduled this, I didn't realize today was the start of the NCAA tournament. I honestly didn't, and so now I'm up against the tournament. So thanks to those who came on, but because of that, I'll keep this shorter than normal. And truthfully, I've been trying to cut these down because I know, people probably don't want to listen to me ramble on for more than 10 minutes anyway. So should be pretty short. Before we get started, couple quick things that we always do. For those who have been on before, you've heard me say this a million times, but we record all these webinars. So if you register, you don't even have to attend, but if you register for the webinar, we will email you the recording of it. And also you can go to youtube.com /Crowe Medicare, or just Google YouTube Crowe and Associates. And we put all our recorded webinars on YouTube. So they're all on there. There's like 160 or 70, some of them on there, and you can watch any of them you want. So if you want to really be bored or have absolutely nothing else to do, you can listen to me go over Medicare stuff. So other thing to mention is if you have questions, send them in, and I imagine we will have some questions on this. Send them into the webinar and I will answer them at the end. And again, the presentation's short, so I will get to your questions at the end. We had really good questions last week. I thought they were great, and appreciate that. So having said that, let's get started. I'm going to go over FCC changes to the TCPA today. So our agenda is the changes that the FCC has invoked on the TCPA. They've made changes to what's called one-to-one consent. I'm going to talk about that. I'll talk about all these things in a little bit of detail. Topically related business, how it's going to try to impact DNC, the DNC list, robotext and robocalls, what people think they're going to do for enforcement of these rules. And again, if those of you who are familiar with the final rule proposal that CMS made regarding Medicare changes, you've probably heard me say before that rule is very vague. It doesn't have a lot of details and it's open to interpretation. This is not very different. This, depending on who you talk to, this is being interpreted in different ways. So I'm going to give you what I think is the conservative, I would say, interpretation of it, but it is subject to definition and later clarification. And this is not proposed, by the way, this is finalized. So just wanted to mention that other thing, that this isn't like not similar to the final rule where we're going to see the final version of that first week in April. This is a done deal. So that's the difference. And again, if you want to watch the recording of this, youtube.com /Crowe Medicare, or just Google YouTube Crowe and Associates. I already mentioned I'll answer questions at the end. I already mentioned I'm ruining the start of the NCAA tournament with this. And then I'm sure I'll get accused of promoism, but I had to just mention really quick one thing, our UHC marketing program. So that's our program that right now for February, March, and April 1st, anybody who writes 8 or more UHC MAs will get $75 per app to be used for marketing reimbursement. We've extended that program, which I'm excited to announce, and for the months of 5/1 through the year, 5/1 through 12/1 effective dates. There will be no minimum for those months. There will be $50 per United Healthcare MA, new to United MA. It's got to be used towards marketing expense and reimbursement. That's what it's for. But anybody who writes any United anywhere, those effective dates 5/1 through 12/1 will get an extra $50 an app to be used towards marketing reimbursement. So just wanted to mention that briefly. Okay, so moving on. Maybe. Here we go. So just really quick, who's the FCC? Well, it's the Federal Communications Commission. They have an act because they're the governing body, and they came up with an act that has rules, and that was the TCPA, the Telephone Consumer Protection Act, which was originated in 1991. It was initially originated to designed to safeguard consumer privacy. It was telephone specific back then. Obviously, as it's gone along, they've made a lot of updates to it, added a ton of language to it over the years. It included things like texts and robocalls and things that didn't exist, back when they came out with it, or not to that much of an extent anyway. So the FCC has made changes to the TCPA. They made those in December of 2023. They're already done. They're final. So this is real. But they gave 12 months because some of the changes they felt were going to be hard to understand and interpret, and they wanted to give companies, I'll say, and people time to adjust. So they made these changes. They're final. They'll be implemented on January 27th of 2025. So what I'm talking about today is a final rule, but it won't be implemented until January 27th of 2025. So I guess if we're really just thinking, not thinking ahead kind of situation, we don't worry about it yet, but obviously, you know, it's going to be here before you know it, and it's going to be major, some pretty big changes. So what changes did they make? So they defined what they consider to be one-to-one consent. So that means consumers can only agree to be contacted rather by one person or organization at a time. So right now, currently consumers are agreeing to a call and a text, and they have a consent that gives the consent for them to be contacted by multiple partners across various business types. So that's going to change. No longer, if somebody goes to look for an online lead or gets a homeowner auto quote, they usually are signing off on a disclaimer, and if they click on the hyperlink, then they'll see all the language that's saying you're giving us permission to contact and permission to share your information with all of our marketing partners, and that could be hundreds of companies. That no longer will be allowed. They're only going to be allowed to give permission to give a consent to that one company or one specific company. So that's a very big change compared to how it's set up today. So one-to-one consent will impact lead gen companies, so lead generation companies, a great deal. It will have a direct effect. I had to look up, was it effect with an A or an E? I'm not good at English. Anyway, I think that's the right one. Direct effect on any type of shared lead, such as a shared online lead. So think about that part. If a lot of leads online now are shared leads, so people go on, they go to get a quote, and that lead is then sold to multiple agents for Medicare, and also it's sold a lot of times to other agents in other businesses, home and auto, window repair. Well, that will be done because they cannot share that lead anymore. If that consumer goes on and asks for a quote, their information can only be shared with one entity, one person. It can't be sold to multiple agents. It can't be resold either. So this will have a huge effect on shared online leads. It'll also impact call leads because a live transfer lead is not considered one-to-one consent. So usually how a live transfer is originated, it can sometimes be from an online form. Oftentimes though, it is from somebody overseas or in the States sometimes, but overseas telemarketing. They will call the person, somebody warm them up on the phone, ask some questions, and then they will transfer that person to an agent with maybe a 30-second or a 90-second buffer and sell that lead to an agent. Well, that is not one-to-one consent because first of all, they got cold called, or even if they found it on an online form, they're talking to somebody who's warming them up, and then that lead is being sent to someone else. It's going to violate one-to-one consent. Having said that, consumer direct inbound calls will still be compliant. So that's a call where somebody goes online, they see a lead, they feel compelled enough to make a call, and that call is going direct to the agent. That is one-to-one. So it's one-to-one consent. So shared leads, so live warm transfer leads will be impacted by this. Consumer direct inbound call leads will still be compliant. So one-to-one consent is going to have a big change. Now, I'm going to talk about in a minute how this will be enforced. It won't have a change maybe to the way we'd like it. But anyway, let's hit topically related businesses. So the consent now must be directly related to the business product type the consumer gave consent for. Because in the past, like I said, somebody might, and if you've received warm transfer leads or bought online leads as an agent, you probably sometimes had the person say, well, I was looking for home and auto, or I was looking to get my windows fixed, or I was looking for legal services. Well, that's because as it stands right now, when they give that consent, their information can be sold to various lines of business as well. And a topically related business is going to stipulate that if the ad was for home and auto, that's all it can be sold for, to one entity or person for home and auto only. You can't sell it across multiple lines anymore. Or same thing with Medicare, for example. So that was my example. Can't have someone shop for an auto quote and then their information is sent to a Medicare agent is a Medicare lead. It's going to make restrict that from happening. Well, it won't restrict it from happening, but there's going to be punishments for it, which I'll explain. Okay, so DNC listings, we're all familiar with the do not call list. I didn't even know this. I thought the do not call list applied to phone calls and texts. It didn't officially apply to text, so they've added that language. So the DNC will be for phone and text now. I thought it already was. I think it's been assumed that by a lot of people, but texts have been officially added. So robocall and texts. So consumer one-to-one consent applies along with topically related business to robocalls and texts. So robocalls are usually the origin of a live transfer call. That's how they start. So this is going to make it so robocalls aren't allowed. They're not compliant unless consent has been given specifically for that one line of business, for that one company to robocall and text people. So no longer can they sign a unknowingly or knowingly sign consent that allows a million different companies to robocall and text them. It's one-to-one with that now, and it's got to be done before those robocalls or texts start. Okay, so those are the main changes. Now the enforcement part, and this is the part people won't like, and this is the part that makes me nervous. So the enforcement, the way it's written, the way people are interpreting this, is the enforcement is going to be all on the person or entity buying the lead. There's going to be very little punishment enforceable or no deterrent for those selling these leads, whether they're overseas or in the United States. And obviously that can lead to a lot of trouble for us as agents. And by the way, if you have questions, please just send them into the webinar. I'm going to answer them at the end here in just a couple minutes, because I'm going to be done in a few minutes. So you get a scenario here where a new rule is going to start being enforced. It's official, January 27th of 2025. It's going to make these things be non-compliant and cause trouble for agents, but there really is no deterrent to keep companies from selling them. Part of this is probably because I think the FCC feels like they probably can't make any enforcement against overseas companies anyway. They're very limited in that regard. Why they aren't going to focus on the companies in the States selling these, I don't know, but that is the kind of overall opinion, is that the punishment will just simply be enforced on those buying and receiving these leads. So new rules, like I said before, rules can be interpreted in different ways. There's various opinions on what this is exactly saying, like especially the enforcement part. But again, the majority opinion seems to be, again, that the enforcement is going to be on us. So again, I don't like that scenario at all, where, as an agent, we're thinking, well, this, company's still selling shared online leads, or they're still selling warm transfers. I guess I'm okay to get them, and we're not, is the reality. So it kind of creates a trap for us. What you're going to see from the actual enforcement against people is the FCC. Obviously, they will be limited by their capacity to enforce this. So I would assume, I'm not speaking for the FCC by any means, but I would assume that they are going to go after the big organizations doing this, receiving these leads. I would guess, because they probably don't have the person power to go right down to the agent level, although maybe they will, but I don't think so. But they'll obviously enforce against bigger organizations. The bigger one for us, if you're an individual agent, is law firm demand letters. You've seen this already, probably. We've seen a bunch of them recently with the DNC list. Basically, agent gets a lead. Turns out that lead was generated from a cold call to somebody on the DNC list, or maybe somebody who's been adding numbers to the DNC every week, and the agent's calling, or somebody's calling a list that hasn't been updated in 2 weeks, and since then somebody's been adding a whole bunch of numbers to it, and they get a demand letter saying, and again, we've had multiple agents get these. They get a demand letter from a law firm saying, you cold called, you called this person on the do not call list. It'll usually say something along the lines of, give us $2,500 or $3,500 or $4,500. And if you don't, we'll litigate this. And if we litigate it, we're gonna connect a lot of different violations here, and then you could be subject to 10, 20, 30, 40, $50,000. So it really makes it tough for the agent. They really need to settle. And usually you can negotiate on the price, but it happens a lot. And then also demand letters from anyone. We've had agents, you don't have to be an attorney to send a demand letter. We've had agents getting leads from people who were called at a number that is on the DNC. Maybe the list was old. Maybe they just added that number the day before to the DNC. They get a demand letter, same thing as I described before, but it's from an individual saying, here are my demands, and it's legal. Here are my demands, send me money or I'm going to use a law firm or a lawyer and litigate this against you. So again, we're seeing this a lot. One thing I can say is for those of you who are calling for med sups, if you're getting DNC compliant lists, which I certainly hope you are, you really need to be updating those things very frequently because new numbers are being added all the time to the DNC on purpose sometimes with that intent. So if you have a DNC scrubbed list and you've been calling it for a couple of weeks, time to get an updated one. You're definitely running the risk of getting demand letters because there's a lot of them being received by people. And that's it. I'm going to see if we have questions. A quick update for you though, before I do that, quick update on the CMS final rule. Talked about that. I'm sure most of you are familiar with what's being proposed. From what we can see, nothing's for sure. The final rule will come out in the first week. The final version will come out first week in April. From what we're being told, it looks like overrides for agencies, FMOs, the FMO distribution system that won't change. It looks, or if it does change, it won't change much. It does not, we're not sure if they're going to levelize that or not, meaning obviously there's 5 states that have higher commission. We don't know if they're going to levelize that to the national level or not. Hopefully not for those of you in those states like Connecticut, Pennsylvania, DC, New Jersey, and California. And the way marketing money for expense reimbursements is distributed is certainly going to change. I don't know that it'll go away, but the way it's distributed will certainly change. Like direct reimbursements for expenses likely won't be allowed anymore. But again, that's what it all looks like. That's nothing's for sure, but that's what it looks like at this point. Let's see if we have any questions. Does the new rule affect mailer leads? So good question. In most cases, no. The only way it would affect that mailer lead is sometimes mailer leads are being used as a permission to call and that lead's being sold to multiple, maybe not multiple agents, sometimes they are, usually they're exclusive, but a lot of times that lead is sometimes being a multifaceted lead for different business types. You won't be able to do that anymore. It's got to be one business type. So if it's Medicare, it's got to just be Medicare. But no, it shouldn't change them much. Are there any lead vendors, let's see. Are there any lead vendors who would be willing to scrub their product against a litigator list? I do not know the answer to that. There is not necessarily a available litigator list. So the way that works is, there's a lot of people out there that are sending demand letters, and we don't know who they are. We don't have a list of them. So that's just a matter of if you happen to call or the lead company you're using calls the wrong number and it's not, it's on the DNC, whether it was just put on there or maybe the lead company didn't run the DNC list or maybe it was an old list. It's just a matter of, is that person looking out for that? And are they a person that is going to send demand letters for it? Somebody said it's too risky to use generated leads now. Well, I would just, with some I agree. I would say certain leads aren't. You could do seminars still. You could do mail. Mail's not risky at this point. But shared online leads, certainly are. Warm transfer leads certainly are. So I would just kind of clarify that a little, I guess. So somebody said, so if we get a business reply card that the member has sent in and we call them, that will still be fine. Yes. Yeah. If they filled out a business reply card, that's built-in permission to call. You're good. Even if they're on DNC, you're cool there. Will the DM rules change or only calls? Yeah, that's applicable. These rules are applicable to any kind of communication, whether it be text. Oh, you mean like direct message online? No, not from what I've seen. Can the agent ask the lead right away if they're on DNC list? If they say yes, agent can say goodbye. You can ask them, but they don't have to tell you. They're under no obligation to let you know if they are. And the fact that, you know, if you ask them that, they could just say no. I'm not on the do not call list, but they might be, and they can still send you a demand letter all the same. So that really wouldn't help you. Can you still call existing clients of other lines of business for Medicare? Yes, you can. Somebody said, thank you, you're welcome. Any other questions? I don't want to overstate this. The big change for this really will be in how the marketing companies generate leads. Now, it did say in there that as agents, you know, we're responsible to know that it was one-to-one consent and that it was like type business. I have no idea how we would know that as an agent. But what I can tell you is if you're doing consumer direct inbound call leads, if you're doing seminars, if you're doing mailers, if you're working with existing clients, face-to-face stuff, this really shouldn't have any impact at all. Again, it is on shared, mostly will impact shared online leads and warm transfer leads. Other than that, it looks like that's all we have for questions, I think. Somebody said referrals are the way to go. Yeah, they always have been. Referrals are by far, if you can generate referrals, well, there you give me an excuse to say something quick. If you're not giving out a referral gift, you should. You can. It can be $15 value. It can't be directly convertible to cash. So like you can't do a Visa gift card if it's convertible to cash, but you can do gift cards. But you absolutely should give out a referral gift and increase your referrals. Ask for referrals because they absolutely are the way to go. They're the easiest close you're going to get, and a great way to build your book. And a big book will generate a lot of referrals. We have books now. I have one here. I don't work my book anymore. It grows every year because of the referrals, and we do a referral gift. If the person sends us a referral, whether we close it or not, that's not their problem. As long as it was a legit referral and the person wanted to talk to us, we send the referral gift, the thank you card with the referral gift, and I recommend everybody do that. You won't notice any difference initially. Over time, you certainly will. And one other tip is initially I sent out things with $15 value, and I then reduced it to 10, and it didn't make a difference. Didn't make a difference. So you can go $10. It's really the thought more and the acknowledgement than anything else. Looks like that's all we have. So I appreciate everybody coming on with me today. Thank you. Again, youtube.com/Crowe Medicare, or just Google YouTube Crowe and Associates. Subscribe to the channel if you could. I should ask people that more often. I get tons of views, not many subscribers. So I'd appreciate that if you could subscribe. And that's it. Thanks you. Appreciate everybody coming on, and I hope everybody has a great day.